We just got some very big news from a federal appeals court concerning the Coach Joe Kennedy case. It sets the stage for a possible Supreme Court appearance, one that could change the way every religious freedom case is argued. I'm Stuart Shepard, and this is First Liberty Live. Before we get started, and you're going to want to hear this one, please remember to like and share our videos. You're part of the success of this particular program, and we appreciate you for sharing it with your friends and family. That's how we get the word out and connect directly with people. Guest today is Kelly Shackelford. He is the President, CEO, and Chief Counsel of First Liberty Institute. Hi, Kelly.
Hey, Stuart.
Always good to have you here. This is one I specifically wanted to hear from you because I got an email from you yesterday that talked about your perceptions on what happened at the Ninth Circuit. And what I realized was what people are going to read in the news and what they're going to hear elsewhere is not what you're about to share, because you have an eye on this that few people do, because you're an expert on the Supreme Court. You've argued at the Supreme Court, and you've got a view of this case that nobody else does.
It's a tremendous opportunity. I mean, I think this is, you know, as we will get into, it's not a victory, but it's set up about as well as it could be set up for the future.
Yeah. All right, let's talk about what happened this week. I know it's a little bit complicated, but just for the rest of us, explain what happened this week in the case that sets up the next thing.
Well, generally, it's at the Federal Court of Appeals. I think almost everybody knows about Coach Kennedy's case. Coach fired for going to a knee and saying a prayer by himself after the football game.
Yeah.
And you go to the Federal Court of Appeals, which, again, unfortunately for Coach Kennedy, he lives in the Ninth Circuit, which is not known for being friendly to religious freedom. And we went to the Supreme Court, came back down, we were going back up again to the Ninth Circuit, and after an opinion by a three-judge panel, you can go what's called en banc, which means there's really, like, at the Ninth Circuit, there's like 29 judges you could get. You just get 3 at random.
Right.
And so you can go to a larger number of the 29 and say, you need to all hear this together because this is a really important case.
And something unusual about this, typically it's the losing party that makes that request, but you got a request from?
The judge, one of the judges on the court that said, hey, I want this to be considered to be reheard, yeah, even though they didn't ask for it yet. And to be honest, I mean, we could have gone straight to the Supreme Court because the court had already said some things about our case that were very favorable, and you know
the Supreme Court did.
The Supreme Court did, yep. And so we felt like it's already set up very well. But there were some judges at the Ninth Circuit that wanted to speak into this, and they said, let's consider. This needs to be looked at en banc. And so when they did that, it caused them to have to issue an opinion, which they just did. And again, there are a lot of really pretty amazing things in the opinions that were written.
And I was going to say, what's helpful about this is, and why they wanted to do that, we didn't expect to win if it went en banc, but what it allows them to do is to enter their thoughts on this case and offer support for Coach Kennedy as expectedly, hopefully, it goes on up to the Supreme Court. So let's talk about some of the specifics of how the Ninth finished up its part in this. First, what did judges who were opposed to Coach's prayer have to say? What did they write in their opinions on this?
Well, again, Coach Kennedy has now been to the Court of Appeals. Again, this is the Court of Appeals in San Francisco. That tells you a lot of what you need to know. And Coach Kennedy, they had ruled against him last time, saying coaches are not allowed to pray in public if anyone can see them. We went to the Supreme Court. They sent it back down and said there's some more facts we want developed. And in the process, 4 of the conservative justices wrote a concurrence where they said that they were very troubled by the opinion below. It would mean horrible things if every time a person who is a teacher, a coach, or whatever, if they ever like pray over their meal at school, if they ever do anything religious, now somehow that's a violation of the law?
Because they said you can't be seen by parents, students, or pretty much anybody else.
That's exactly right. And so you know, that's where they were. We went back to the same panel, same 3 judges who had ruled against him before. They ruled against him again.
Shocker.
Yeah. And then, of course, because, again, this is the Ninth Circuit in San Francisco, this group, and it would, the main of those 3 judges, the main judge, Judge Smith, wrote the concurrence for denying the en banc, saying we're not going to reconsider all as a group. And in that, he did a number of very unusual things. One, he misstated the facts, which he had done a number of times before, and that's not going to work out well for him, in my opinion, because we can cite the record.
Yeah.
But he wants to create a different world than really existed.
And that was something I watched because this was when they heard the case back months ago. It was on a Zoom call because, COVID. But I watched our attorney representing Coach Kennedy repeatedly, over and over, with the patience of Job, kept correcting their misstating of what happened. It was like it was a different coach on a different field at a different school in a different universe that they were describing. But the attorney for Coach Kennedy kept saying, no, here's what the record shows. Here's what actually happened in real life. But yet, in what they wrote, that foreign universe, that alternate universe, showed up again.
It was one of those amazing things. Usually our supporters can't go and watch an argument at the Federal Court of Appeals because they'd have to go to the courtroom, and there's not a lot of room in that courtroom. And this time, because it was all on Zoom, we let all of our supporters watch it. And the most common response I got from people was how outraged they were of how this judge kept trying to change the facts. And it was obvious to people watching it. This judge, by the way, his entire career before he was a judge, he defended school districts.
Oh.
So he's obviously comes from a different perspective, and I'm sure he'd like to see the facts a little differently. But the truth is, he tried to make it like Coach Kennedy was trying to create some sort of media approach, and he wanted to speak his mind on the issue, and that students were going to come around him in prayer, when it's the very opposite. Coach Kennedy made a decision years and years ago that he would go by himself to the center of the field, go to a knee, and say a prayer after every football game, which is what he did.
Yeah.
And in fact, in this time when he was fired, he specifically went when the students were turning around to sing the fight song so they wouldn't be with him, and they weren't with him. So I mean, it's just all these attempts to sort of color it in a way. And by the way, the reason the media covered this is because he was fired.
Yeah.
He was being threatened. He would rather just do his prayer like he did for years and years and years without any coverage at all. So,
and shockingly, people care about a story where you have a football coach who's doing a silent prayer on the 50-yard line. His private commitment, his personal commitment to do that. The media is interested when suddenly they hear the school district's going to throw him out, fire him, take away his job.
Absolutely. And again, we had been to the Supreme Court before. They said there's some more facts they want to develop, but the 4 justices said that they found this very troubling, what was said below. So they had seen what went on. They knew the facts. The record is there to cite. So this was, I think it'll only help us in getting the Supreme Court to look at this, because when you have judges trying to reorganize the facts in weird ways, they realize something's going on here, and it makes them look more closely, because this is going to affect millions and millions and millions of people across the country. Everybody, not only who's a coach, everybody who works for a school district, everybody who works for any government entity around the country, because what this would mean is, well, what if you're a teacher and you bow your head over your meal? Well, you're now a violator, because you can't be doing that, because some student or some, it doesn't even have to be a student, by the way, some citizen might see you from 100 yards away and say, ha, 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 they work for the government, and look, they're praying right now over their meal. It would take away religious freedoms for millions and millions of people across the country.
And so they doubled down on those initial arguments, changing the facts, because they wanted to argue a different case. Frankly, they didn't want to be arguing this one that was actually in front of them. But also, one of the judges basically cited theology, tried to make a theological argument.
That was one of the most shocking things. The judge cited scripture and his own religious beliefs about how people shouldn't pray in public. Well, that's a little, there's a problem with this on a lot of levels. Number one, think of the idea of the judge saying, not based on the law, but I don't like your religion, plaintiff, and therefore that's part of what I'm going to cite in my opinion as why I'm going to rule against you. Well, that makes the whole decision unconstitutional before you even get to the results itself. It's just, you can't do that. But number two, it's like, okay, if his theology, this judge's theology, is now going to control, then I guess we've got to overturn all this precedent about having prayers before legislative sessions, about the founders having prayer before, Congress. I mean, it's just outrageous to even go the direction, but his direction would lead to incredibly extreme results. Again, helpful to us as we go to the Supreme Court to go, not only is this decision wrong, there's clear bias here in what's going on against Coach Kennedy.
Let's talk about the judges that supported Coach Kennedy and his personal commitment to say a silent prayer after each game. They wrote in favor of Coach Kennedy's case. What did they say?
Well, there were a number of them, so it's not just a couple. I mean, a whole bevy of them. I didn't even count them up. I think 10 or so. And what they said is that this is actually an excellent case for the Supreme Court to take because so many errors were made, and it would be such a travesty in the precedent it would create if they didn't. In particular, they said, look, the majority's main argument was that somehow Coach Kennedy was engaging in government prayer by praying by himself. And they said, anybody with a brain knows he wasn't praying for the government.
Right.
He wasn't there as a government speaker. And again, if that's the new law, that anytime you're working for the government, you have all your religious liberty stripped away, we have totally changed the law, because the law has been for 50, 60 years now from the Tinker case that neither teachers nor students shed their First Amendment rights at the schoolhouse gate. They have a right as citizens to express their faith, to pray, to wear a cross around their neck, to, you name it, right? Mm-hmm. And this would change all that. And so they said, you're converting these people into government actors so that you can strip them of their constitutional freedoms. And they said, this has to be taken, because they were pointing out, this is not just even in the school context now. This would do that to everybody, whether it's a police officer, whether it's a county clerk, whether, you name it. Everybody in every local government, national government across the country has their religious freedom stripped away. And they said there were so many errors they went through, and this is kind of unusual for a court of appeals, a bunch of judges to say, this is actually a really good case for the Supreme Court to take, but they laid that out really beautifully, I thought, and set this up. They also pointed out, by the way, they said, this has already been to the Supreme Court. They sent it back down for factual, development of some things that weren't clear, but they kind of made clear where they were on this, and they referred to the decision by the Ninth Circuit as really a defiance to the Supreme Court. And I think that's really true. And again, I think that's not a good way to have the Supreme Court not want to take your case, yeah. Is when they send you a message, being kind somewhat, to say, you know what, this is really disturbing what you did here. And then when it comes back to you, you just double down on how you're stripping away freedom. So this is going to go back to the Supreme Court, I think, in a really good posture.
And one of you were talking about the Supreme Court sending it back to pick up some facts. I want to use this picture behind us. This is a reenactment, if you will, but that's Coach Kennedy at the 50-yard line where he took the knee. I shot this last year. And part of what they wanted to say was, if you're in the stands and you see that guy, what's he doing? Could he be taking a phone call? Could he be checking the turf? Could he be looking for something somebody dropped on the field, a necklace or something? Might he be saying a silent prayer? You can't tell, can you?
Well, but they knew. They said, because there was so much media attention.
Yeah.
So evidently, if the media covers your case, you lose your freedoms. So it's a new context, what they were trying to argue. But what they tried to do is say originally that, well, we're not so sure why we took the action, because it might have been because he really wasn't performing his duties at the time. Or it could have been because he was praying. Well, when we went back down, it became very clear, because the Supreme Court said that's what we want. We want to make clear, why was this done?
Right.
And they said, well, okay, it's because it was religious and because he was praying. It wasn't because he wasn't doing his job. It wasn't. Right. And that
because he did his job very well. Oh. I mean, what started this whole thing was a compliment from one of the opposing teams, someone that was associated with the team, who wrote a compliment to the superintendent and said what a great job he's doing.
And everybody loved Coach Kennedy. I mean, but what they did when they reestablished this and said, okay, it was because of religion.
Yeah.
I mean, they bolstered our case,
yeah.
Right? I mean, it's clear his speech was targeted because it was religious speech. He was targeted because of the free exercise of his religion. It wasn't an accident. It was focused on him for those reasons. Now that's clear. it makes the case even stronger than it was before as we head back to the Supreme Court.
Not that many months ago, we sat here and had a conversation about the Bladensburg Peace Cross. It's known as the American Legion case because we represented the American Legion in that one. And something you pointed out was, among the other things that happened in that, most of the justices at the Supreme Court wrote in their opinions that something called the Lemon test is dead. That decision got cited by the judges on this particular action at the Ninth Circuit, and they specifically talked about whether the Lemon test was dead.
It was, again, this decision, I think, although it was against Coach Kennedy, as we expected, was so positive in so many ways for the future. And this is one way. When we won the American Legion case, the Bladensburg Cross case, our main goal was really to get rid of this Lemon test, which had created the government to be hostile to religion. And while it was only decided in that case, which involved a veterans memorial, our goal was to make this more permanent and to spread it into other areas so the hostility to religion would stop in all areas of society. Well, in this case, all the dissenters in their opinion said, Lemon is dead. So that's great that our decision essentially killed Lemon. I mean, Lemon is dead, and they're already stating this. But secondly, they took it out of just the public monuments, and they said this should equally apply in the schools as well. This sort of hostility to religion shouldn't be allowed there either. So it's really encouraging to see the results of our victory in the Bladensburg Cross case being carried forward all the way across the country. You know, we won that in Washington, D.C. Now we're, in Washington, and they are saying, yeah, and even in San Francisco in this decision, and they're saying, yes, this is starting to change the whole country, and the hostility to religious freedom is on its way to be dead.
And that sets up this next idea, and that is Bladensburg was larger than just a World War I Veterans Memorial in an intersection in Maryland. This case is a lot larger than Coach Kennedy's job at a high school in Washington State. What's the larger victory that could be won here if, I'd like to say when, but we have to say if it goes on up to the Supreme Court and we win?
There's a number of ways it's larger than life, larger than normal. Number one, if you look at decisions regarding those who are coaches or teachers at our schools across the country, there is almost zero precedent at the Supreme Court level to give them protection. There's a statement in the Tinker case that says neither teachers nor students shed their First Amendment rights at the schoolhouse gate, but that's about it. And so this would be a major decision that establishes that they do have religious freedom, they do have free speech. So that would be really a landmark decision. But even more so, when we went up to the Supreme Court last time, the Free Exercise Clause has been really hampered for over 30 years now, 3 decades, because of a bad decision called the Smith decision that has somewhat neutered the ability to use the free exercise of religion as protection in the United States. Yeah. And many people have thought, well, gosh, I'll just bring a free speech claim because I'll say it's religious speech. And that's what most people do because you can't get much protection under the Free Exercise Clause.
So under the First Amendment, it talks about the free exercise of religion. It talks about free speech and other things. So what you're saying is no one ever would bring a case and say, hey, this is protected by the free exercise religion part of the First Amendment because of that Smith decision.
That's right.
So you hop over to the one just after that, the Free Speech Clause.
That's right. And so that's what's been happening. But when we went up earlier on this case saying we want you to overrule the Ninth Circuit, they said, well, we're not going to take it yet because we want this fact about why did you really fire him? Mm-hmm. Right? But then 4 of the more conservative justices, and this is before Justice Barrett was added to the court, said, by the way, we noticed that the first claim to reach us was a free speech claim, not a free exercise claim. Maybe that's because of the Smith decision that's caused so much damage to religious freedom over the last 30 years. But we haven't been asked to review that decision yet. Not a subtle hint that they're ready to reconsider Smith. So this case could very well be, they've already given the signal, as we go and say, you need to take this case. Not only could they correct, so you're asking, how could this be bigger than life? This could be the case that changes the precedent, that really restores the Free Exercise Clause to every American. And many people are predicting it very well might be that case. So I would encourage people to pray because Number one, Coach Kennedy needs to win his case. What's been happening to him now for many, many years
It's just wrong.
Is wrong.
Yeah.
And it's also going to affect everybody else. We need more Coach Kennedys in this country, not less. It's going to affect those teachers and coaches all across the country. But even more than that, it's going to affect your free exercise of religion, whoever you are in the United States, because if we win and we get rid of Smith, which I think we can, we're going to restore. Everybody's going to have more free exercise rights than they've had in decades. Most people than probably they've been alive.
Yeah.
And that's an incredible opportunity that sits right in front of us.
I want to help underscore why we're hopeful about this case as we start the process here to appeal it on up. That is, you mentioned that there were 4 justices who wrote a note saying, boy, we'd like a little more about this case. How many justices does it take for the Supreme Court to accept a case?
Only 4. And again, since those 4 issued their concurrence, sending their message last time, we've added another justice by the name of Amy Coney Barrett, who's very well known to be somebody who understands and cares about religious freedom. So most people would assume she would probably be in the line with those 4, and you're at least at 5. And there are other justices, like the Chief Justice, who has been fairly pro-religious freedom himself. You might be at 6 at least.
Choosing
to
hear the case.
Saying, this is a case we need to hear. This is important for religious freedom. And so this is a tremendous, we've been given lots of things in this opinion, which was wrong. The dissenters did an incredible job of laying out the arguments and why this is crucial that the Supreme Court take this. And it's an opportunity for a pretty significant change for our country that would really restore religious freedom across the country.
Real quick, what's the next step in the process for First Liberty Institute?
We have 90 days now to file what's called a writ of certiorari, which is really just your request. It's a brief, it's legal arguments to the Supreme Court saying you need to take this case.
Right.
Here's why you need to take this case. The other side will have a chance to respond, 30 days or so to respond, and then there'll be even a chance for us to file a quick reply. And then the Supreme Court will, either within days or most likely months, will look over it and they will make a decision as to whether they take the case. So I would encourage people to be praying, number one, for all the work that we're about to do and making the arguments of why they should take the case. Pray for the justices that they, really be moved upon to take this case, and that really this could be the case that really makes some major change. And one of the wonderful things is everybody at First Liberty, all the supporters of First Liberty, everybody who prays, they get to be a part of changing history in a major way for their kids and their grandkids. And I think it's a very possible result of what's happening here.
Ordinarily, we'd wrap up the discussion right here, but I wanted to give you a chance to do something. First Liberty has been on a roll lately. I wanted to give you a chance just to give a quick update on a number of cases where we've had significant victories just in the last weeks of time. So I'm gonna give you the topic. You tell me what happened real quick, and then we'll go on. It's kind of a lightning round. We'll blow through it. But I wanted to give people an idea of what we've been enjoying here inside the building. We want people outside to have the joy of that as well. First, the Supreme Court just took one of our cases, not this one, but a different one.
It's the case out of Maine, the Carson case. This is a huge deal. I'll let people know. There's about 9,000 to 10,000 requests a year. The Supreme Court takes 70 cases. They just took one of our cases that we and the Institute of Justice are working on together.
Yeah.
It's a case out of Maine where they say, you know what, you can pick any school for your children, and we will reimburse you for your tuition, public or private, as long as you don't pick a religious school.
Which is wrong.
Well, that's religious discrimination.
Yeah.
And I feel really strongly that we're about to get a great victory at the Supreme Court. This will be a year from now. We'll have to prepare the briefing, do all that, have oral arguments.
Yeah.
But everybody who's a part of First Liberty, we're going to the Supreme Court.
And we'll talk more about that as we go along, but we wanted to let people know about it. The next one, chaplain invocations in a courtroom.
We have a great guy we're representing by the name of Judge Mack, who has a chaplaincy program that ministers to people. If you're a justice of the peace in a small county, you're also the coroner.
Yeah.
So he would go and people would be dead, and he would have to write cause of death. Well, there's distraught families, individuals, and so he got all the ministers, all faiths, all denominations, all religions to volunteer their time to minister to people in those horrible circumstances, and then they could also open up his court sessions in prayer.
Yeah.
Lawsuit was filed to strike that down. A judge very erroneously issued, yes, we don't allow those kinds of prayers. I don't know what country they think they're in.
Yeah.
And then the Judicial Commission went after Judge Mack to punish him for what he was doing. We just got all of that reversed by a federal court of appeals that said this is wrong, really took the district court to task, took the commission to task, and I love that for Judge Mack and what it's done for him in protecting what he's been doing.
And then Christians Engaged got a letter from the IRS saying, no, you can't be tax exempt as a nonprofit. That got turned around.
Oh, yeah. That's probably one of the most talked about cases over the past 2 weeks. They were told by the IRS that their tax exempt status was not granted because they said they were aligned with biblical values, and that biblical values are more closely associated with the Republican Party, and therefore they would not be granted tax exempt status.
Which is very helpful for the IRS to say that in so many words.
Oh, I mean, every church now would have to have its tax. Anybody who goes by any sort of Judeo-Christian values, you got to take away their tax exempt status. It's an outrageous decision. It was in writing.
Yeah.
Good news is it's no more. It's been thrown out. The IRS reached out to us personally, apologized, said this will be corrected, and Christians Engaged now has their tax exempt status. And more importantly, it's a precedent really for people across the country to be protected to do that if they so choose.
That's a prime example. All these are, but that one in particular of how if you didn't know any better and you got that letter in the mail like, oh, okay. But that's why it's so important to have an organization such as First Liberty Institute that will represent, that will get involved and get the IRS to pay attention rather quickly and get this thing turned around. Okay, out of D.C., COVID restrictions on churches.
Yeah, we not only won the final victory for Capitol Hill Baptist Church, which was a church that was not allowed to meet outdoors with social distancing and mask, despite the fact that protests were allowed across D.C.
Yeah.
Final victory was an agreement by the city that they will never interfere with a church service again in the future. That's a pretty strong right.
That's proper separation of church and state, might I add.
And they paid over $229,000 in attorney's fees for what they caused the church.
Yeah.
So a victory all the way around.
All right, Chaplain Calvert.
A great chaplain, served in the Army for many, many years, and has been a wonderful chaplain. They were going to end his career, letter of reprimand, because he expressed a religious belief on his Facebook page that transgenderism in the military is a bad idea and is a bad idea biblically. By the way, the same approach that the commander-in-chief himself, President Trump, said at the time, but yet they were going to push him, throw him out of the military with a letter of reprimand because of that. Well, we just won the reversal of that just a few weeks ago. So again, a great victory, not only for the chaplain himself, Chaplain Calvert, but really for every chaplain, because it sends a message of the protection. If chaplains can't express religious beliefs on their own Facebook page, we've got serious problems in the military.
Yeah, well, one last one. There are many more, but we'll do this one. High school graduation speeches had a couple of wins there, too.
We had a valedictorian who was told that it would be inappropriate for her in her personal farewell valedictorian address to mention her faith. Now, what was inappropriate was for government officials to try to tell a young lady who had earned the right to give her speech that she couldn't mention her faith. We not only won that case, she got up and gave her valedictorian address, and in fact, a lot more people saw it because it was on video and carried around the country.
And it was good.
But other students saw that, and that said, you know what, this is happening to me.
Yeah.
And so we had another case. So victories in both of those valedictorian cases where the school was fighting, and in these cases, both these young ladies who stood their ground and got up and gave their valedictorian address, honoring God and their faith in their valedictorian address.
So for those of you who support First Liberty Institute, thank you. We just wanted you to know it's been busy around here. We've been doing a lot. If you could speak directly to our supporters about all of this and the impact of it, what would you say?
Well, number one, I'd just say thank you. I mean, I think going back to May, we've had 12 victories in a row, and the Supreme Court just granted, the certiorari in our case.
Yeah.
And then now we've got Coach Kennedy on. I mean, It's incredible. I mean, I've never seen anything like this. I mean, I've just been thanking the Lord. This is God's favor, and we've been getting victory after victory after victory, and everybody who's a part of First Liberty has participated. Your fingerprints are on this victory, every one of them, whether it's the IRS, whether it's this case they just took at the Supreme Court, whether it's you standing with your arms around Coach Kennedy. This is a great time. I mean, we know that the attacks are greater than they've ever been, but we're getting more victories than we've ever gotten. So I think if we'll just be faithful, not only are we winning, but we're really starting to turn the precedent and turn the law in a way that is really positive for the future. So I just want to say thank you to everybody for being a part of one of the most incredible times in our country's history when it comes to religious freedom.
Very good. Kelly, thank you for the work that you do. Appreciate it so much. Thank you for your insights today. Very helpful.
Thank you.
Hey, if this resonates with you, and if you want to see outcomes like this, please, on firstlibertylive.com, look up at the top of the page for the big red Give button. You can be part of this. As Kelly just said, your fingerprints can be right on these victories and the ones to come. We're hopeful for victories in Maine and also for Coach Kennedy from coast to coast. So if you want to be part of that, your support for First Liberty is a way that you can express your desires in the real world in these actual cases. And also, if you want to learn more about Coach Kennedy, go to firstliberty.org. That's our main website. And you'll see a big photo of the coach right there on the homepage. If you click on that, there's a lot more information for you, and we'll keep you up to date on what's happening in that case. We want to keep you connected with what's happening with Coach Kennedy as we make this next step to ask the Supreme Court to take the case. Kelly, next week we're going to talk about military chaplains. Next Thursday is the anniversary of the establishment of the Army Chaplain Corps by General George Washington. No big deal. We're going to talk to Ron Cruz about that next week, and that will be right here on First Liberty Live.